Justice of the Republic of Ghana, her leadership, it's Mami Tokono, Isaba Gertrude, Nini, the Minister of Channel, her leadership, Isaba Tokono, Gertrude, I can say, on an asem about just gonna who be I, then a pampan, you'll be a ball left, right, center. Now, I'm playing on penny is escalated the Mahama say, oh, see petition. Petition, if you want her, is that the Yansa Kalipa to say petition or show a dear comment from Yansa, and I'm petition at the comma a Mahama. And Mahama forwarded petition at the comma council of councillors is almost a ding. He said, then something now about to do judges, a Bibia, a Kui, a Yamagana. Tsikata and Zwaka da fasa and say when you could see the Eba.
Madam Justice Gertrude Tokonu Isaba Araba is the learned Chief Justice, and we know that there has been some petitions against her, and we also know that there's a court case that will be heard tomorrow. Apparently, the injunction application will be heard tomorrow. The injunction application was adjourned sine die until further notice last week. Is now being set to be heard tomorrow, Wednesday, at the Supreme Court building by 5 judges. Arguing in favor of the injunction will be Godfrey Adame, who is lawyer for the Honorable Vincent Asifua, Member of Parliament for Old Tafo, and arguing against the motion will be Dominic Ayini, the Attorney General, the embattled Attorney General as far as Kwame A+ is concerned. The Attorney General who is leading the oral investigation, the Attorney General who is leading the government prosecution is now being told by Ghanaians. Ghanaians are now hearing from a member of parliament that this same said Attorney General, according to Kwame A+, is corrupt. And we don't know whether that is correct. Kwame A+ is saying it. So the Attorney General is embattled. He will be in court tomorrow to make his arguments against the injunction. Before then, we have obtained, as have some other media houses, the document of the petition. Now, because we try to protect the integrity of the process, we are not going to show you the petitions in raw hand, but we do have it. We have paraphrased some of it and we have rewritten some of it, sometimes in very similar words, but the account that we are going to give largely reflects what is in the petition. Sometimes it is verbatim, sometimes it is paraphrased for the purpose of protecting the integrity of the process under Article 146. So let's start. All right. So this is the first petition. Now, the petition alleges that the Lord Chief Justice unfairly and unjustifiably ordered for the arrest in open court, and that the order is an abuse of office. So the petitioner here is alleging that the CJ unfairly ordered for the his arrest in open court, and that the order is an abuse of the office of the Chief Justice. News portals that we found have reported that it was he, the petitioner, that was ruled to the bench, not just the Chief Justice, but the entire quorum that sat on the matter. Quorum just means the panel. Was ruled to the bench, and hence necessitating the arrest of the petitioner for contempt of court. So here is a petitioner who is a lawyer. He had a case in court. He went to the court. He was unhappy with it. He was unhappy with the verdict, and then he started throwing tantrums in the court before all the panel. The Chief Justice was sitting before all the panel. And what do? If it's in Parliament, the Speaker is going to ask for the marshal. We know that already. The Speaker will say, where's the marshal? Hey, take him out. If I go to Parliament and I smuggle myself in the chamber while they are sitting, and before they see I'm in the chamber, and I say, hey, good evening, Ghana has come today. Hey, marshal, take this man out. And the marshal will come and bundle me away. If I wrestle with the marshal, he will hit me. If I hit him, the policeman will come. So that's what it is. So this petitioner then sends a petition to President Mahama that I went to court and Chief Justice said they should arrest me in the court. So President Mahama receives it and they are looking at it. And then when you check the date on which the thing occurred, and you check the date of there's a platform called the Law Platform where many lawyers are. It was reported on a Law Platform and completely condemned. That's where we got the information from. Completely condemned by all the lawyers. How can you do that? So he is petitioner number 1. It's not very complicated to dismiss a petition like that, but we are not the Council of State and we are not the President. But from what we found, this is a no petition. In fact, the petitioner should be fined. He should be fined for bringing a petition, wasting the taxpayers' time, wasting Council of State time. But that's our verdict. We don't know what the President and the Council of State will.
you are the four and it's for I just said the Echo Sony the Epa and work on a hand concerning CJ Uva and I was soon able to our witty and so many dear as a supplant much pass almost why you in train with Jack Eddie Mammy or comment section where young
the Council of State will decide. But the facts of the matter, as we check it, which we can all prove it, that on this occasion, this guy went to court and he threw tantrums before the court, and then the court said, well, sorry, we have to get you out, and they took him out. That is his allegation. Now there's a second petition. Here the petitioner alleges that the Chief Justice's recommendations for the appointment of more justices to the bench was unconstitutional. This ground has already been subject of other petitions, and the same ground has been dismissed. Further, a mere recommendation to the president does not usurp the president's powers to nominate members of the Supreme Court. This is a very interesting conversation, this one, because when it happened on social media, some members of the National Democratic Congress were sharing the document, and I'm not sure what the course of action is, but let's discuss it. So the allegation is that the Lord Chief Justice wrote a letter to the president in response to a conversation, a request from the president, an oral request from the president, because the letter says pursuant to our conversation so and so and so. So the President Akufo-Addo in question here, the president had a conversation with the Chief Justice, made an oral sort of request that, can you send me some names for consideration for Supreme Court? That's what is in the document. And then the allegation here for the grounds of impeachment is that and this came in the Kweku Asare document. It was in the Kweku Asare document, and President Akufo-Addo dismissed it, but they've repeated it. So I don't know what the Council of State is going to do about that. He says that the recommendation that she has made recommendations for justices to come onto the Supreme Court and is unconstitutional. It's very difficult to assess this matter, because the recommendations for the Supreme Court that the president takes, he can even take it from me. He can take it from anybody. He doesn't have to tell whoever what he's done. When the president is ready, he will take his pen with the secretary in front of him, write a list of names, and send it to the Speaker of Parliament. When the letter gets to the Speaker of Parliament, it is not part of the Speaker of Parliament's job to find out that, Mr. President, the name Paul Adumochi came from who? The name Paul Adumochi came from John Mahama, because you, President, John Mahama is your friend, and the other day we saw that you and John Mahama were at the Pinkberry at Hacho, near the Chicken Man. So we suspect that it's John Mahama who did this, and then they go and write a letter and say that John Mahama has made recommendation to President, and that is not his job, so we are impeaching John Mahama as Chief Justice. I don't even get it. Whatever conversation the President and the Chief Justice had is inconsequential to the legal process. You cannot therefore say that the Chief Justice was making recommendations to the Supreme Court. It is the President who can complain. That's why I was asking that, what is the course of action? Who is complaining? If the Chief Justice has usurped the President's authority, it's the President who is the proper complainant in the matter. He can come and say that, hey, Mr. Speaker, the Chief Justice is usurping my authority because he has sent you a list when it should be me. But I don't see the head and tail of this. The list went to the Speaker from the President's hand. Finito, end of story. Whether Judicial Council participated and they have a right to do so under the Constitution, Chief Justice is a member of that. Whether the Chief Justice in his individual capacity wrote something to the President, whether a former Supreme Court judge sitting at home observed that the President was about to make nominations, wrote something to the President, said, Mr. President, please consider A, B, C, D. Justice Kwegan is still alive. He's a former Supreme Court judge. If there are opportunities for Supreme Court, he can write to President Mahama and say, Mr. President, please consider Mr. Paul Adumochi, Mr. Godfrey Dame, Bafuewa for Supreme Court, because I think they are good judges or they are good lawyers. They are doing something like that. This is what they are saying, that because she wrote a letter to the President making recommendations, she should be impeached because she was doing an unconstitutional act. Who is complaining? This is the President's job. The President did his job. The President does his job by writing to the Speaker. The President did that job and wrote to the Speaker. The vetting was conducted. What is the point about this? But we are not the Council of State. The Council of State will look at it. But this is one of the petitions. Let's move on to the more detailed one. Now, this petition, we're going to take quite a bit of time to deal with it, because it's from a man called Daniel Ofori here. Now, let me explain to you about Daniel Ofori so that you can get it well. In 2011, Daniel Ofori sued EcoBank to enforce the terms of a shared trade transaction between the parties. This would have compelled EcoBank to provide funds for Daniel Ofori to acquire shares in another bank. The High Court ruled in EcoBank's favor. Okay. Daniel Ofori is a very active guy at the Ghana Stock Exchange. He's one of the reasons why the stock exchange has been active. He's been there for a while. Daniel Ofori entered into a transaction with EcoBank. Sorry, we have to mention EcoBank's name, but the other bank we will not mention. And Daniel Ofori wanted a loan from EcoBank to acquire shares in another bank whose they had done what do the bankers call it, a call-up offer. How do they call it? After the IPO and they need money and they do a call-up, that thing. So they had done a call-up offer, and so Daniel Ofori, as a shareholder, wanted to maintain his shares and acquire a few more shares. So he wrote to EcoBank for a loan, and then I think they were doing the transaction when, for some reason, the Bank of Ghana decided that that bank cannot do that XYZ, something like that. So in 2011, EcoBank then refused to advance Daniel Ofori the money. So Daniel Ofori sues in the High Court, saying that EcoBank has to give him the money. Okay. Now, the High Court rules against Daniel Ofori that you cannot have that. You can't have that. The case is entitled, I believe, Daniel Ofori versus EcoBank, or EcoBank versus Daniel Ofori. There's Daniel Ofori versus EcoBank, there's EcoBank, Daniel Ofori, several of them around. Okay, so this is the said Daniel Ofori. So he sued, and the High Court said, no, you can't have the money. Then he goes to Court of Appeal. The Court of Appeal confirms the decision. This is in 2013. The Court of Appeal confirms the decision of the High Court and held that EcoBank was not bound to pay the sum owed to Daniel Ofori.
You are the four anything for I just said the Ecosony the Epa and work on a hand concerning CJ Uvan and our son goes to our witty and so many dear as a supplant much pass almost why you train away Jack Fefe Edia Mammy or comment section for young Quem you could see near to us soon. Enter
the Supreme Court in 2018. The Supreme Court ruled in favor of Daniel Ofori and held that Daniel Ofori was entitled to a sum of 13.2 million Ghana cedis and 30% interest on the said sum from the date accrued from June 2008. Now, the first transaction was in 2008. The conversation about buying shares of another bank was in 2008. That was the date, 2008 to the date of the judgment in July 2018. It's very interesting. Okay, so at this stage, Daniel Ofori has won the Supreme Court's decision. All right. At this time, Justice Tokonu is not a member of the Supreme Court. Chief Justice Gertrude Tokonu is not a member of the Supreme Court at the time the Supreme Court made this decision. All right. Now, EcoBank discovered instances of alleged fraud in the share transfer, and hence the case should be reopened. The court rejected the application and refused a review of the decision. This is very interesting. So later on, Justice Tokonu becomes a member of the bench of the Supreme Court. Now, EcoBank, in now looking at the matter, as Supreme Court says that they have lost, they need to pay Daniel Ofori so much money. They are looking at it, and their lawyers discovered that but there's some fraud in the application, in the first High Court application. Look at the documents that he presented. Okay, so they allege fraud. Now, once you allege fraud in any matter, you can always go back to the court and say, oh, my laws, wait. I have now observed some fraud, and they should look at it. So EcoBank applied for the Supreme Court to reopen the matter, and they failed in that application. The Supreme Court did not reopen the matter. Then the EcoBank appealed against the Supreme Court's decision not to reopen the matter. I believe it's at this stage that Gertrude Tokonu is now part of the court, the Supreme Court. And in the review application, I think Gertrude Tokonu participates in the review application. EcoBank still lose the review application, but now it's not unanimous anymore. Justice Tokonu is able to convince other Supreme Court judges, including Justice Doche, to rule on her side, because in her argument, something called compound interest, based upon which the Supreme Court took their decision, is a nullity, because compound interest, she said, had been nullified by Parliament. There's nothing like compound interest. How can then the court calculate compound interest? These are the arguments in the document. So some of them sway on that side, but the majority are still with Daniel Ofori. Okay. EcoBank thereafter go to the High Court, seeking to stop the execution of the ruling of the Supreme Court, because the Supreme Court they will not hear them on reopening the case, and they lost the review on that by a slimmer verdict than the unanimous 5-0 that they lost by in 2018, which was to say that they owe Daniel Ofori, they should go and pay. They come back and say, yes, we may owe him, but there's fraud. Supreme Court says, I will not listen to the fraud. They appeal against that, and then some Supreme Court judges, including Justice Tokonu, think that, look, you should listen to this, because compound interest that you are talking about doesn't even exist. Anyway, so EcoBank now go to the High Court and ask the High Court judge that we have observed this fraud. Can you stop the execution of the Supreme Court ruling? And any court, even a lower court, can stop a decision of implementation of a decision of a higher court, so long as there's fraud. It's in the rules. So that is where we are. So EcoBank has now won the High Court's position that the thing should, the implementation, the execution should hold, stay of execution, that execution should be stayed pending the final determination of their fraud case against the said Daniel Ofori. Tsikata is one of the important lawyers of Daniel Ofori. Now, Daniel Ofori is a petitioner against the Lord Chief Justice. Let's look at it. Hello, Mr. Tsikata. How are you? We are talking about you on TV tonight. Not in bad terms, but in very neutral terms. So, Mr. Tsikata is one of the most important lawyers of Daniel Ofori. And I told you to get me the video of Tsikata and Tokono. Please look out for it. Let's use it. All right. So, okay, Mr. Tsikata, thank you very much. Good. Now, so Daniel Ofori writes a petition to oust Justice Tokonu as Chief Justice. We are saying and giving you the history because Daniel Ofori feels that, and he's told people that it is because Justice Tokonu came to the Supreme Court that his matter started becoming logoligi lagalaga logoligi lagalaga. Daniel Ofori feels that it is Justice Tokonu, or perhaps Daniel Ofori is being told by his lawyers that it is Justice Tokonu who is in fact, in the petition, he directly points to Justice Tokonu sitting on the EcoBank case. Listen, let's start. All right. Daniel Ofori starts with money, suspecting that Justice Tokonu has spent some money and she used some money to travel, and the money that she used to travel is not for her, it's for government and blah, 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 blah. Let's look at it. Okay. This is on the left is the allegation that Chief Justice misappropriated a sum of 261,000 Ghana cedis of public funds for private travel. Daniel Ofori further alleges that the CJ traveled with her spouse, that is her husband, and child with the aforementioned public funds, when her spouse and child are neither members of the judiciary nor work within the judicial service. So this is Daniel Ofori's first allegation. There are three categories of allegation: financial, court matters, and then another one. I'll show you all. Give me just 5 minutes. So this is the matter, that she has spent this amount of money traveling with her husband and her daughter. This is what we found, that the said travel package is provided for in paragraph A9 of the policy on foreign travels by the head of the judiciary and superior courts judges, approved in 2010 and reviewed in 2019, and it allows the CJ to bring along a spouse and another person of her choice on foreign travels. This has served 4 chief justices, to wit, Georgina Wood.
You are the 4 and 84. I just said the Ecosoni, the Epa, and we're gonna have no concerning CJ Luvan, and I was so able to our witty and so many dear. As a supplant, much a pastor once while you train away Jack Fefe, Eddie Mammy, or comment section where young women, you could see near to us soon.
Sophia Kufu, Justice Eniye Boa, and Justice Tokonu, the present CJ. So where is Daniel Ofori coming from? Even we were able to find the policy on travel, and that's what we did. Once we saw the thing, I said, okay, let's get the policy. Today is what, Tuesday? We've been working on this since, I think, last Friday. So we said, let's get the policy. Is there not a policy for traveling? So we picked up the policy. It is clear in there. And in fact, in some of the instances we saw, Justice Tokonu, when she traveled, she came back and returned cash of nearly $9,000 to the judicial service. That I didn't spend all the money. This is the rest of the money. When I saw it, I was telling my people that, but this, my lord, $9,000 you can issue to buy. Say that you bought books from London or something, buy something. And they said, well, that's how she is. She's like that. She came, she brought the money back. So because they raised this allegation, it has allowed people now to look at it. And everybody's finding out, oh, the last time Justice Tokonu traveled, we gave her some money. She brought back $9,000 that she didn't use it. This is the kind of person they want to impeach for corruption. So how many ministers, how many ministers travel with the impress and come back and go and give the money to the chief director that I didn't spend the money, finance manager, here's your money. No, people don't do that. I'm not saying they should do that. But I'm saying when you have somebody who has done that, this is not the person that you say is corrupt. You cannot say that is corrupt in the same breath of a person who takes money and returns the rest of the money. You cannot say that. But anyway, so this is the policy. And viewers, you can check, you can verify. Tomorrow, call the judicial secretary, journalists, everybody, check. What is the travel policy at the judiciary? Check it, it's there. They'll give it to you. They gave it to us easy. They'll give it to you. It's a public document. It's not a secret. And the document says that it is, so it's in paragraph A9. So when you take the policy, don't go far. Just look at paragraph A9. Let's look at paragraph A9. And that policy is on foreign travels. It's by the head of the judiciary. So this is a policy that came in 2010. It has existed and it was reviewed in 2019. Reviewed to add security, actually. It has existed for Justice Georgina Wood, Justice Sophia Kufu, Justice Eni Yeboah, and Justice Tokonu, and this is what they want to impeach her on. That she traveled with her husband and traveled with her daughter, and this is the money that Justice Tokonu returned 9,000. This is 260 something. That's what they're talking about. Is that not what they're talking about? No, that was another one, another 14,000. So they have two of her trips. This one and another one. The one that she returned the money. They don't say she returned the money. Maybe they don't know. Daniel Foy doesn't know. I can understand. But this is what we found out. Anyway, let's go to the next one. It says, this is a very important one. Very, very, very important. Again, because Mr. Tsikata is lawyer for Daniel Ofori, and Mr. Tsikata is also lawyer for Jachikwesin. And the Attorney General told us in his press conference, when he was asked by journalists, why didn't you enter nolle prosequi for Jachikwesin? Dominic Ayini told the journalist that Chachu Tsikata has told him that as far as he, Mr. Tsikata, is concerned, the Jachikwesin case will be won. So he need not enter nolle prosequi. This is the conversation the Attorney General reported. This kind of conversation going on in the judicial circle. This is what the Attorney General reported. The letter Attorney General told Ghanaians that he did not enter nolle prosequi for Jachikwesin because Mr. Chachu Tsikata, who is lawyer for Jachikwesin, has told him, Dominic Ayini, that as far as he, Mr. Tsikata, is concerned, the Jachikwesin case is doable. And so he doesn't need a nolle prosequi. So was he entering nolle prosequi for cases that are not doable? What is the meaning of doable? What is doable? 2-3 days ago, Jachikwesin won his case and they put powder on his head and on Mr. Tsikata. So you see, sometimes the dots are coming together a little bit. Daniel Ofori, then in his petition to Mr. President Mahama against Justice Tokonu, Tsikata is his lawyer. Tsikata is also lawyer to Jachikwesin, says this, that the Chief Justice interfered in the Jachikwesin suit by causing operatives of national security to seize computers used in the trial. The Chief Justice also transferred staff that were accused of being involved with some unexplained activities involving the trial. The Chief Justice also transferred staff that were accused of being involved with some unexplained activities involving the trial. Now, this is why I blame the judiciary, the judicial service. They must, as a matter of urgency, appoint a director of communications in the judiciary. The way the world is going, they must have a lawyer, proper lawyer, 10 years at the bar. In fact, it must be 10 years at the bar, who will be elected after interview as the director of communications at the judicial secretary's office. Because if what I'm about to read to you did happen in Ghana and we didn't hear about it, then we must blame the judicial service. Listen, this is what we found. According to the story as documented, the attention of the Chief Justice was drawn to the fact that the record.
Tell you what's up, no good in done. Your hustle, aqua Charlie. I tell you what's up, enjoy the ride.
Record of proceedings on the 19th July 2023 in the Jachikwesin trial had gone missing. Can you imagine that? And nobody told anybody. No journalist knows. No Joy FM. No CTFM. We don't know. And the judicial service is sitting down. And today you see what they are doing. The person who went to delete the Jachikwesin process may be the same person who is.
You are the 4 NAT for I just said the Echo Sony the Epa and work on a hand concerning CJ Uvan and our son a good to our witty and so many dear as a supplant much pass once while you in train with Jack Fefe Eddie Mammy or comment section where young Quem you could see near to us
claiming something. Listen to this. The Chief Justice was told that the Jachikwesin trial, a whole day's conversation in the trial, had gone missing by the judge in the matter. The judge in the matter said, "Hey, my lord, I'm dead. Oh, look, Jachikwesin, a whole day of, I can't see it. It's gone. I needed to assess to look at the rest of the case. The whole day, the thing is gone." I'm sure they asked him that, "Do you remember what happened that day?" He said, "Judge, he cannot remember. He's writing everything down. The record of proceeding is missing. Somebody went and stole it. Somebody went and stole the process of the Jachikwesin. And judiciary didn't tell journalists. They didn't do a press conference. That day, no, they should have issued a statement that the judiciary is concerned that the proceedings of 19 July has gone completely missing and that we are investigating it. And they should have published the results of the investigation. Democracy has changed, though. Please, judicial service, democracy has changed. It's not the old one anymore. Now it's TikTok and Instagram. You have to talk. Look at this. When I found out, I cringed. I said, but why didn't they tell anybody? Look at it. The 19th July, the Jachikwesin trial has gone missing. She, Gertrude Tokono, then commissioned an investigation which was carried out by the National Signals Bureau, which found out that there were severe and significant internal breaches. To remedy these, the administrative decision was taken that persons who had control over the record were to be transferred away from sensitive processes of record keeping. This is what happened. Are you connecting some dots? Who was at National Signals Bureau? Kwabena Edubuahin. Who did Attorney General say? Kwabena Edubuahin. Who is lawyer for Jachikwesin? Tsikata. Who is lawyer for Daniel Ofori, the petitioner? Tsikata. Who is the Attorney General? Dominic Ayini. Who is Dominic Ayini? Tsikata's. Is it coming round nicely small? You can now see the dots. This is what's happening in Ghana today. This is what is happening in Ghana today. People sit down there in the comfort of their homes and decide that a chief justice must be removed because it is about them. It's no longer about the constitution. It's about their ego. It's about their pomp. It's about their pomposity. And it's about their exaggerated events of themselves. They consider themselves as an event. And it's very highly exaggerated. This is it. Look at this. The Tsikata has never told anybody in any press conference that there was one day that the record went missing. He's never said that. How many press conferences have been granted on this Jachikwesin matter, and nobody from the Jachikwesin side has ever complained that there was one day record missing, and the judicial service too didn't tell us. It's an unsolicited advice. Judicial service, please have a lawyer of not less than 10 years at the bar, properly appointed as the director of communications of the judicial service, sitting in the office of the judicial secretary. Is very, very important because of things like this. Look at this. Jachikwesin filing a petition against the chief justice is able to go and Daniel Ofori is able to go and bring a Jachikwesin matter. Lawyer for Jachikwesin, lawyer for Daniel Ofori, Attorney General, National Signals Bureau, Kwabena Edubuahin. You see the whole thing. Kwabena Edubuahin, sorry, pa. It's your work that you were doing. You haven't done anything wrong. When Chief Justice called your team to come and look at it, you did your work. And these are electrical engineers. They are very solid people. Kwabena Edubuahin and his team, they are very smart. So they found out that this has happened. And I'm wondering why the judicial service till now merely transfer people who are manipulating justice by removing a whole day's record out of the thing. Nobody says anything about it. And they now sit in the comfort of their homes because their friend is president. Their party is in power. So they now want to remove the chief justice when she was the one doing the right thing. Wrong is right and right is wrong. We should never allow that. Let's move on. Now, the petitioner here alleges that the chief justice arbitrarily transferred judges in the Daniel Ofori case. This is it. This is another allegation, the Daniel Ofori one. So he alleges Madam has spent money on her son and daughter and something they traveled. He doesn't know that there's a policy. Then he comes to Jachikwesin. He doesn't know that there was a National Signals Bureau, proper and thorough investigations done, and his people were found out. He doesn't know that. Then he comes and now says that, okay, now I'm coming in my own capacity. You, madam, you transferred judges who are doing Daniel Ofori case. This is what he said. This is what he said. This is how and why transfers are carried out. Let's move on. EcoBank versus. So Daniel Ofori says that in the cases that involve him, Madam Gertrude Tokono transferred the judges. Let's see the details. Now, the first one is EcoBank versus Daniel Ofori. Transfer from Justice Boansi to Justice Mereku. Now, Justice Boansi requested to travel out of Ghana because both her husband and child fell ill. She she was granted permission to see them, and all cases before her were transferred to other judges, inclusive of Justice Meku. When Justice Boensi returned, she was taken ill and had requested leave. So Daniel Ofori does not even know that the reason why Justice Boensi's the case was transferred from Justice Boensi to another one is that the lady herself requested, and the documents are there. She doesn't request
for anything for I just said the Ecosoni the Epa and Wakana Hanum concerning CJ Uvan and I was soon able to our witty and so many dear as a supplant much repass almost why you train over Jack Fefe Edia Mammy or comment section for young women you could see near to us soon.
Request by letter. He doesn't. It's a document. It's a letter. It's there. So he is petitioning President Mahama that he should sack Gertrude Tokonu, because when I took cases there, he's just transferring the people. He's transferring everybody. It's my case, and he has transferred somebody. So you should sack. I mean, viewers, permit me to bring myself. I have a case at the High Court. One day we went to court. They said that the judge has been transferred. So based on that, I can write a petition. So my friend Kwabene Japan becomes president. Then I go to him, Kwabena, hey, Justice Tokonu on say me case on not transfer judge no. They say, oh, judge not transfer, me judge not transfer. Oh, for petition, you know. Is that how we run a country? Yeah, I have many friends. Let me take some money from the NDC. Spio Gabra is my friend. Guzitano used to be my friend. I say used to be because I've not seen him in a while and I don't know, but yeah, used to be. So Guzitano becomes president. Oh no. Asedu Nketia, you all know Asedu is my friend. Asedu Nketia becomes president. Then I go to him, General. Charlie, let's put bygones at bygones. So me here be pa. I say, Kasema, you a bad boy. I say, Judge, no, Chief Justice, no. Say me case be na me yo kumase na say case. Oh no, transfer judge na. I didn't koye basasa. Say, oh, what's that be na that pankro no. Oh, any for petition ba you know. It looks like that's what is happening. It looks like that's what is happening. That your case has been transferred. If you take from Philip Archer 1992 and bring Chief Justice who have transferred cases, you find numerous of them, because that is their work. That is their job. They do that all the time. The Constitution has given them the power so to do. And then Daniel Ofori is bringing an application to the president because the Chief Justice has been transferring judges that have to do with his case. Really? Daniel Ofori, come again. Why? Now we're there. Well, again, we are not the Council of States. We don't know. But this is the fact. So this is why Justice Meku found himself in the EcoBank matter. Then there's another one. Daniel Ofori versus EcoBank. Transfer from Justice Lodo to Justice Meku. EcoBank petitioned for the case to be heard by the same judge to avoid multiplicity of suits, pursuant to Order 1, Rule 1, Clause 2 of CI 47, which provides that matters in dispute must be determined and multiplicity of proceedings must be avoided. So because Meku was handling this one, it made sense that Meku will handle all pursuant to Order 1, Rule 1, 2 of CI 47. Daniel Ofori has lawyers. Didn't they tell him this? Didn't they tell him? But I'm sure they didn't think that the petition will come out public for everybody, all of us non-entities to see it and be talking about it on that your TV. As they tell me, you go and sit on that your TV and you are fooling. Yeah, they didn't think that non-entities will see it and go and sit on that their TV and be fooling. But now here it is.
Therefore, anything for her, and I'm doing this very, was I in Michelle, and I from her, I am Ghanatube so much.